Despite its name, North Carolina's Worker Safety Act of 2026 isn't about hard hats or safety equipment. It's about something almost as important. What happens to an employee after they report a safety problem and get punished for it? House Bill 258, the Worker Safety Act of 2026, it became law, Session Law 2026-13, effective immediately upon passage in June 2026. It passed the House 108-5 and the Senate unanimously 46-0, genuine bipartisan agreement. Sponsors included Republicans Kyle Hall and Charles Miller, alongside Democrat Sarah Crawford. Here's an interesting wrinkle. This bill didn't start out as a worker retaliation bill at all. Earlier versions of House Bill 258 were actually titled the Utility Worker Protection Act, covering a completely different subject before evolving into its final form. So what does the final version actually do? It modernizes something called REDA, North Carolina's Retaliatory Employment Discrimination Act. REDA protects employees from retaliation when they do things like report unsafe working conditions, file a workers' compensation claim, or raise a wage complaint. If an employer punishes a worker for doing one of those things, firing them, demoting them, cutting their hours, REDA gives that worker a path to file a complaint with the state. This bill doesn't change what counts as retaliation, it changes how that complaint process actually works. First, filing requirements. A REDA complaint has to be filed within 180 days of the alleged retaliatory action. The complaint has to include specific information: who's filing it, a description of what happened, the date of the most recent retaliatory action, and the complainant's signature. If a workers' compensation claim is involved, the complaint also has to include the relevant workers' comp form. Second, what happens if someone files an incomplete complaint? Before, that could create real confusion. Now, the Department of Labor has to notify the person of exactly what's missing and give them 30 days to fix it. Third, timing gets standardized too. Once the department receives a complete complaint, it has 20 days to forward it along in the investigation process. Fourth, and this is a change that benefits employers specifically, businesses can now submit something called a position statement early in the process. That's a written explanation of the employer's side and any potential defenses, submitted right at the start rather than late in an investigation. The idea is straightforward. Investigators get a fuller picture of both sides sooner instead of piecing the story together later. Fifth, the law clarifies how materials unrelated to a specific investigation should be handled, helping keep the process focused and appropriately confidential. North Carolina's Labor Commissioner praised the bill directly, saying it brings, in his words, common sense reform to make sure retaliation claims are handled fairly, consistently, and efficiently. He also framed it as a two-sided improvement. Workers get a process that's transparent and responsive, while employers get a process that allows all the relevant facts to actually be heard. It's worth pointing out what this bill doesn't do. It doesn't expand or shrink the underlying protections against retaliation. Those substantive rights stay the same. Instead, this is a procedural overhaul, making the process of filing, investigating, and resolving these complaints clearer for everyone involved. That kind of change doesn't always make headlines, but for someone actually going through a retaliation complaint, procedural clarity can be the difference between a fair hearing and a frustrating, drawn-out mess. It's also a reminder that not every major labor law fight in a legislature ends up split down party lines. This one passed with near unanimous support from both parties. The bill is part of a broader set of labor and workplace proposals that moved through North Carolina's 2025-2026 legislative session. For employees, the practical impact is this: filing a retaliation complaint should now come with clearer deadlines, clearer requirements, and faster movement through the system. For employers, it means an earlier opportunity to formally respond rather than wading deep into an investigation to make their case. House Bill 258, the Worker Safety Act of 2026, modernizes North Carolina's process for filing and investigating retaliatory employment discrimination complaints, setting clear filing requirements, a 30-day cure period for incomplete complaints, standardized deadlines, and an early opportunity for employers to respond. Do you think this strikes the right balance between protecting workers and being fair to employers? Or does one side benefit more than the other? Let us know what you think, and if you learned something new, hit like and subscribe for more breakdowns of the laws shaping North Carolina.